Alrighty, part two of This Week People News. Okay, let's go ahead and get started.
Is the Romans do have something which they call a universitatem, which is a sort of an aggregate, which is supposed to be a corporation, but they don't have the corporate term. So if you look at the Latin, this universal phrase means sort of everybody is all in, and then you get, again, the wrong translation, where they treat this as a corporate body, which of course is not what it is. But you can see what they're clearly driving at. There are certain forms of property, like public buildings and so forth, which you have to find some way in which to organize and to own. And you don't have a clear conception of public ownership, so you kind of create this hybrid term in order to cover the case. We see it mentioned in both Gaius and Justinian. We don't see its implications fully spelled out, but we know enough about that situation so that when we get to the law of property, you can see how it is that this particular thing fits into the larger system.
In what other ways have Roman laws involving persons shaped our modern legal rights?
Essentially what happened is the Roman law shaped them in the following way. It made it appear perfectly natural and ordinary that the individual human being was not the unit of legal personality. And so when you start to come to Anglo-American law, it may be that the paterfamilias disappears, but the relationship between husband and wife changes. So there's a legal maxim in the earlier days which says that the husband and wife are one as a matter of law, but they're two as a matter of fact. Well, then you have to decide where the distribution of power lies in that particular arrangement. And so what you do is you end into a period of essentially husbandly dominance over the kind of an arrangement, and the women is subordinate. Well, if that's what happens in marriage, then what you have to do is to worry about what happens to women before marriage, or women who choose to remain single. And, it was a very painful situation to essentially decide that they had full rights to contract in one form or another, to own property, to make wills, and so forth. And this was only clarified in the period after the Civil War. The rough American evolution, in crude terms, is that all of the stuff having to do with the private law material was sorted out between about 1865, the end of the Civil War, and about 1900, with the many forms of the Married Women Property Act. As often happens, it's social forces that are driving this. So you see a single development starting to take place in England and in the United Kingdom. But there's also the political side on this. And essentially what happens is political rights and civil rights were thought to be exactly the opposite under this tradition. Civil rights dealing with private law, political rights dealing with participation, voting, participation, and so forth. If you look at the American Constitution, it's pretty progressive on that. It turns out there's nothing whatsoever in the original Constitution that starts to give preference for men over for women. There's not a sex qualification for serving the president or in the Congress and so forth. The only time that you start seeing sex introduced into the Constitution is in connection with the modification, not the repeal, of the 3/5 rule, which took place in Section 2 of the 14th Amendment, widely forgotten today, which essentially says when you do the various calculations having to do with voting, you only look to male inhabitants. It's an explicit sex distinction in Article 2, which is then declared unconstitutional by reading Equal Protection in Article 1 to overcome it. That takes place in the 1970s. It's also a case in which, when it came to the position of the slaves, the states were given an option. If they don't include former slaves in the denominator, they can't be included for calculations, they're just out. So if you want to have the greater number of people, you have to let them vote. But you have the option to exclude them from voting and just take a small position in the Electoral College and in the Congress. And you can see, essentially, this is not modernity speaking, but this is part of the kind of awkwardness that always happens in political transitions. If you didn't see this Section 2, you would never imagine that something like this could happen, but there it sits, and it only requires careful reading and explication to go on. What we then do is we, of course, have huge battles on voting with respect to both race on the one hand and with respect to sex on the other hand. On the race side, essentially, there was systematic exclusion that took place one way or another. There were what they called grandfather clauses, and what these said is you're allowed to vote in this election if your grandfather was allowed to vote in this election, but since your grandfather was a slave, you can't vote. And this essentially remained good until about 1915, when essentially the Supreme Court came down and said this is just a covert restrictions on voting. You can't use this stuff. Every person has an equal right to vote, notwithstanding this. And then you have another 50 years in which there's essentially dogged resistance to extending the franchise to black individuals on 1,000 different grounds. The voting rates are amazingly low, coercion, all sorts of official qualification, polls tax, and so forth. This essentially only gets unglued in the mid-1960s. The Voting Rights Act of 1965, which followed on the heels of the Civil Rights Act of 1964, is the sort of the legendary and vitally important provision dealing with this stuff. But this issue still continues to be of very, very great importance inside the American framework today on all of the preclearance and other enforcement methods. A key case called Shelby County shows just how divisive this issue can be in modern times, and it all stems from the fact that when you are trying to undo a terribly unjust system, it's much more difficult to know when you're successful or to figure out what remedial measures turn out to be needed. So that's on the race side very quickly. On the sex side, it's a somewhat easier survey. And for one thing is that the system of de facto exclusion, which existed with respect to race, never existed with respect to sex. On the other hand, women, unlike slaves or former slaves, were married to rich and powerful men. They often had great intellectual and personal distinction of their own. And so there was a suffragette movement which took place here and in England, which essentially agitated, sometimes with violence, often not, saying, why are we excluded from the polls? It makes absolutely no sense that we should be governed by the political polity if we can't participate in the way in which it's organized. It's profoundly anti-democratic. The resistance of this continued until the end of World War I, and then in rapid succession, first in England in 1919 or 1918, and then with the amendments in the United States Constitution in 1920, women were given the full right to vote. And that kind of ended the thing with respect to voting, in the sense that participation rates immediately became high, and there was no sort of backdoor efforts to keep women from voting under these circumstances, which created the same kind of situation that you had with the Civil Rights Act. And more importantly, whereas you can racially gerrymander a district so as to give blacks or whites more or less influence, an issue which is still of great importance to this very day, you can't gerrymander differences on the grounds of sex to say, well, we're going to put Manhattan this way because there are more women than men, and we're going to do Albany the other way because there are more men than women. That just doesn't exist. So on the voting front, it turns out that the sex issues kind of gets a more or less conclusive resolution, whereas on the race issue, it kind of goes forward. But both of these things in the political dimensions are a direct legacy of the fact that even after civil rights to enter into contract, make wills, and so forth were more or less taken care of, the political dimension took at least another 50 or 60 years. And in the case of racial discrimination at the election, the battle is still very hot and heavy today. It's no longer the momentous issue that it was in 1965. As John Roberts pointed out, black participation in Southern elections is now often higher than white participation in the same elections. So whether you like the rules or not, you can never say that this is an issue of crisis performance. This is just an issue in which the honest people could have very, very severe differences.
Thank you for listening to this episode of the Number 86 lecture series. The spirit of debate of our founding fathers animates all of the Number 86 content, encouraging discussion and critical reflection relative to how each subject is widely understood.
Alrighty. This week, People News. Till next time. Bye, y'all.